You have to stop using your brand name or we're going to sue you. What would happen if that actually happened to you? You got a cease and desist order and you could no longer function as the brand that you've grown to be in the green industry. Well, it's not fiction. It actually happened to one of my clients. And I can tell you that they went through hell trying to fix this. What's going on? It's Chad with Landscape Leadership. And if you are in the green industry, you're a company owner or professional in the lawn landscape industry, guess what? You are in the right place, because this is where we tackle really hard, awkward conversations like this and try to equip you with the tools to recover from these issues, or better yet, to prevent them in the first place. So I'm going to give you a little background. I'm going to tell you a little about the story. I'm not going to give the name of the person this happened to. I'm going to tell you what happened. So we're going to make up a fictitious company. Let's call them Coastal Plush Lawns. Coastal Plush Lawns builds a really strong brand. They're operating for 10, 15 years. They have all kinds of marketing out there, all sorts of assets, truck wraps, signs, all kinds of print literature, a website, all kinds of ads running. You name it, they have a lot of things going on for them. And all of a sudden, a company named Plush Lawns is franchising and moving into their market and is demanding that they stop using their company name. So they have either one of two choices. First, they're probably already spending a bunch of money with an attorney to figure out what they can do. So that money is already spent. The options are either fight this big brand in court and see if you can win, or put your tail between your legs and spend a lot of money still to try to change all of that branding. Well, sadly, this actually happened to one of our clients, and we've helped them recover from that, redid the website, changed all kinds of videos, images, you name it. It was a big expense, a big project, and now they're on good ground again. But I want this not to happen to you. Also, on the other side, if you are a brand, and we don't want someone infringing upon you. So today I invited trademark attorney Richard Reimer onto the podcast today. Hey, Richard.
Hey, Chad, how you doing? Thanks for the
Good.
intro.
I appreciate you joining us today because I'm not an attorney, and I've learned a little bit in bits and pieces about trademark law and these cases as we went through this with a client. We also trademarked our brand and our logo and some things there. So I'm learning a little bit, but I'm realizing just from talking to my clients and colleagues in the green industry, a lot of people don't know much about trademarks or why they should have them. So thank you so much for joining us today. I hope you can shed some light on this.
Absolutely. Well, Chad, that's a great hypo we can play with today. And it's something that happens way too often. You know, one thing that you said in the way you set it up was you've made up this fictitious name and away you go, Coastal Plush Lawns. Unfortunately, that's the way most of our clients name their businesses. They just sort of on the spur, hey, that sounds good, let's go. And with the same amount of research you did, which you admit was none, off they go. And they don't know what they're facing. I love to sort of turn the light on in a dark room so people can understand what's inside that dark room.
Yeah. So, Richard, why don't you give, I guess, answer some questions from you. So, what are some specific things that company owners can trademark?
Well, trademarks are really any sort of device that the public looks for when they're looking for you, for your company versus all your competitors. Generally speaking, we think of names, the name of a company. We think of logos. We think of taglines. We could be thinking of color schemes. We could be thinking of packaging designs. It could be a store layout. Heck, it could be the interesting design you put on a landscaper's shirt, the design that show up on the landscapers when they come to do their work. So there's a lot of things, but anything that you put out there that's supposed to distinguish you from anyone else. It could be noises. You think of the MGM lion roar, the NBC tones. There are a lot of different ways that you can say, hey, this is us.
Yeah. Okay. That's a lot of stuff. So, what are some things that brands think that they can trademark, but they really can't?
The things that brands try to trademark all the time that just really aren't protectable are common or generic words. If you have a client, and you're using your example of a company that's in the landscaping world, and you want to have exclusive rights and lawn cutting services, sorry, you can't. But clients come to me all the time thinking that because they can, they have started calling their products this, or they have their service name for that, that they can somehow claim exclusive rights on that, and they really can't. There are sort of ways around it and ways that can help people that have that situation, but you'll never be able to claim exclusive rights over words you can find in the dictionary that are defined as the same way you're using it. So take Apple for a second. Apple obviously is a very common word. We all knew that word way before the computer company came along. However, it had no connection to computers whatsoever until Apple came along. So it's not that the word is common, but it's common in your industry.
Okay, so that really helps to clear that up. So I explained in the beginning, this is someone reacting to someone's trademark claim, but what can brands do? Like, I'm thinking like trademarking kind of insulates you, insures you against your competitors. So how can that help protect a brand that isn't trademarked yet?
Well, there are different ways to get rights in a trademark. The way that almost every company has rights from day one is simply by using their brand in commerce. You get an incredibly narrow set of rights just simply by having your company name out there. And more important than the company name, the name you're calling your services. So if you're operating under a DBA, it's the DBA that's getting protection, not the name of the home company that's just filed away with the Secretary of State. So simply using your brand name or your logo or whatever it is in commerce, meaning out there for sale, is enough to get you some protection. What I can help people do is get enhanced legal rights in the brand by getting a trademark registration. So enhancement happens in three different ways. When you're looking at whether or not brand one infringes brand two or not, you look at several things. Likelihood of confusion is the test as a whole, but do they geographically overlap? Are the brand names themselves similar in appearance or in sound? And finally, are the services they're selling or the goods they're selling related to one another? When you have common law rights, you have to have nearly an identical match to find infringement. However, when you have a registration, your geographic rights go from whatever town you're in to national. Your similarity goes from it has to be nearly identical to that just needs to be similar. And the relatedness of goods and services goes from they need to be nearly identical to they just simply need to be related. So it's almost like taking your small little right and putting it on steroids. You now have a much larger right with the registration.
Yeah, that's basically what happened to my client, sadly, is that, there was another company that started this brand and the name, like if you would hear it, you'd be like, yeah, I can see that. But, like we were kind of like, that's just not right. But it's law. And they had trademarked that name and they, started 4 states away and started spreading and franchising and getting bigger and then moving into my client's market. So now all of a sudden they had a claim and he didn't. And it's unfortunate. So that's why I'm always telling clients to do that. So what are some risks that your company would run into if you're not trademarked, other than the one that I just mentioned?
Well, I think you have mentioned the real big risk, which is someone else might have superior rights to your brand and can make you stop. Now, you laid out pretty well. There's really two different ways that that plays out. Either one, you capitulate and immediately give up and you're rebranding and going through all those expenses, or you fight. And one thing that you didn't really put in the argument with the fight is in addition to losing and having to go through all the costs we talked about already, you may also have to pay damages to the other company.
Oof.
So if you have been operating for a number of years in infringement of the other company, you would have to owe them, in theory, your profits you made for those years. However, if they have a federal trademark, you triple that amount and pay their lawyer's fee as well. And
Oof.
there's nothing worse. I mean, I think my clients dislike paying me, even though I think I do a good service for them. What they hate even more is paying the other guy's lawyer. That is really a big kick in the pants. So you really want to be careful before you start any brand that your brand is not infringing. There's some really simple ways to take care of that.
Okay. So what happens if you get your trademark approved and you do want to, you have a trademark and you want to pursue possible infringements like that?
Right. Well, again, you need to make sure that you actually have an infringement case in front of you. Infringement really is I have superior rights over you and a brand that is similar in nature in connection with similar goods, related goods and services. Geographic is one thing that often is problematic. Taking your client's example, so we had big bad national company. Let's say they're in the north coming to the south, and you're in the south. When they're in the north exclusively, excuse me, just in a simply different geographic zone, they can't sue you for infringement because there is no overlap. There's no one to be confused. No customer is going to think, should I call company one or company two? Because they don't overlap. It's once the overlap starts that you have a potential infringement. which leads you to the second question of, well, who has priority? You would think that if company one moves into company two's territory, company two would have the superiority because they were there and someone else moved in. However, with a trademark registration, that essentially gives you a reservation to move into any part of the country later on when you choose to do so. So when they're just to the north, they could maybe send a demand letter saying, if I ever get to the south, I will sue you. Often they don't because it's not really worthwhile. But once they move to the south and they do have the superior right that they now have the ability to enforce, they can then sue you. So you have a lot of companies that might look in the yellow pages or maybe look in their Secretary of State database or something simple like that and say, no one has that name. I'm golden. But they fail to acknowledge the federal rights that someone might have and later have a claim of superiority over you. I kind of consider it almost the same as like getting season tickets at a football game. Just because you don't show up to a particular game, those seats are still yours. Whether or not you choose to occupy them is your business. You're probably not going to have the usher remove people from your seats in a game that you're not present. But once you show up, get out.
Yeah, that's a good analogy. We run into trademark issues just very little like that, but the one that we frequently have run into is with Google Ads. So Google has, they do have links to the Federal Registry of Trademarks. And if you try to use a trademarked term in your ad, they will reject and pause your ad. So there are some big brands, and we already know that just because from trial and error, if we try to use their name in an ad, it's not misleading, but even like compare us with and that name, that Google will shut the ad off. So we already know, like going into that we're not going to use that. We're going to say compare us with the big national lawn care chain, and so then the language is changing and that sort of thing as well. We can still target those terms, meaning if someone's searching for that company name, you can still serve your ad up. There is nothing wrong with that. It is
Right.
not unethical. You can also even mention them in comparison marketing as long as, this is my understanding, you can correct me if I'm wrong, as long as you're not like throwing mud or being unfair. So, we've done that. We've done, here are three or five best lawn care companies in your area, and we mention them by name, but we're using very objective information. Like this is the services they offer. This is how long they've been in business. This is their public business model. This is their local locations, Google review and rating. That's it. That's all we talk about. So you have to be careful with that. I actually got one of our competitors the other month because I was doing a search for our company name and saw somebody else's ad. And actually, so it's landscape leadership, and the terms that they were using, it wasn't landscape leadership, but it was so close that I was like, hey, you know what? I want to report this ad and see if I can get it shut down. And sure enough, Google shut it down because they thought it was still, again, we're both green industry marketing agencies and they're trying to do a little play on words so that they're going to steal our traffic. And I guess that is enough we have a trademark. So that's enough to say, nope, you're not going to do that. So we're the fortunate benefit of that. I appreciate
Yes.
that. But
That's certainly a useful tool. And it's funny, some other things, that's sort of Google turning on its power because of trademark registration. Amazon, I realize you don't deal with a lot of companies that would be on Amazon, but they too have a brand registry that having the registration gives you so much more right in the world of Amazon.
Yeah, good. So if someone is, thinking about pursuing getting things trademarked, what kind of cost would they be looking at, just roughly?
Well, Chad, I'd like to actually start you back one step because whether or not you think your brand is worth getting trademarked or getting registered, someone else might think that your simple use of your brand is infringing and you might be causing a problem just simply by existing. So
Mhm.
it's not going through the registration process that causes the problem. It's you going into business that causes the problem. So before you open up your doors, before you have your name slapped on your truck and on your website and all the other million places you might put it, pay someone like me to do a search. That is not going to the USPTO and just simply putting in the name and saying there's a direct hit. That's not a search. That's something a monkey can do. I subscribe to tools that go through tons of databases that make sure in a lot of different ways that there's no one out there that might have a superior right to your brand. That's a $550 project. And it could save you your profits for the first several years of your existence.
Definitely.
It's a very easy thing to do. And the thing I've found that's real problematic that really seems to frustrate small and mid-sized businesses is the large company that could sue you seldom sues you on day one. They seldom sue you the day, the week, the month, even the year you open your business. And the reason for that is simple. They don't see you. You've not made a splash. You've not made an impression. You've not crossed their radar screen. So they don't know about you to sue you. When they tend to sue you is when you do something scalable, when you do something that's growing, when you go through a large marketing campaign like you might help them with, or you acquire a neighboring supply company and you're, or neighboring company that you're doubling the number of trucks you have, doubling the number of lawns that you're taking care of, or doing something to get bigger. That's the point at which the competitors tend to see you and the competitors tend to go after you. So you finally feel, wow, I'm making it. I'm doing something big. And then wham, here comes a cease and desist letter. So definitely before you get to that scalable moment, make sure you've done something that gives you some confidence that your brand name is not going to lead you to problems. Now, you asked specifically about getting a registration. So we'll assume that you've crossed the threshold of thinking that your company is big enough that you want to protect it. Getting a search is step one, but if you've already done it, you've already done it. So you kind of know what the limitation of your rights are, who you might be at risk of infringing, where they are, what type of rights they have. Maybe they only cover Bermuda lawns and you do fescue lawns. I mean, who knows? There could be something as weird as that could separate the two of you. But you know exactly where you stand, where they stand. Going to the Federal Trademark Office and filing an application and going through the prosecution process is about a year-long process. Okay. Now, a lot of people kind of look at the federal application and think that's kind of simple. I know the name of my company. I know what brand I'm trying to protect. I know what services I have. But in many ways, the simplicity kind of fools you. It kind of lulls you into a false sense of confidence. Not knowing what your rights are, what risks you have, and just going forward and filling out the application as simply as it looks would be like asking a professional golfer to shoot at a hole in golf, but not letting him look at what he's shooting at. His golf swing might be really pretty, but if he doesn't know what he's aiming for, what he's hoping to achieve, he's never going to be successful. So that search helps inform that and helps you prepare a good application. Even with all that effort, one thing that shocks people is the trademark office reviews 100% of the applications filed and 85% get refusals. Now, that's not because the trademark office is mean or because I filled out the form poorly or someone else has filled out the form poorly. They simply want to challenge every single application and make sure that everything that becomes registered is warranted, has earned it, is really worthy of that right. We want registrations to be a gold standard. So there's a lot of scrutiny that happens along the way. Getting a refusal is not the end of the route. It's just part of the journey. It's almost like thinking your vacation's over because you have to stop and get gas along the way. It's just part of the journey. It's how it goes. But overcoming the refusal, first of all, understanding what refusals are likely to come will be revealed in the search. What strategy you might have to overcome them, how likely you are to overcome them will all be revealed in the search. And then when the refusal comes, you're prepared to have a response that's likely to get overcome the refusal that the government raises, and you move on. There is also a third-party chance to oppose, but that happens very rarely. And finally, at some point, you need to show that you're actually using your brand in commerce and demonstrate that to the government. So those 4 steps: filing the application, responding to government issues, responding to third-party issues, and showing your brands in use are the 4 things that you need to do to get a registration.
Okay, so up to a year, you said approximately. Of course, prices will vary and change, I'm sure, by scope, but 550-ish bucks to look for, any potential issues. How much is the process then to that whole package to end up to trademark your company? I know it probably varies based on what things you're actually trademarking. Is it logo? Is it slogans? Is it this? Is it that? What's like a range that a business can expect?
Well, Chad, you're absolutely right. There are variations, and ones I can walk you through that are objective, that, I can explain why yours would be different than his or whatever. And the price to do both the search and the application all the way through government review is $3,500. That assumes you're filing in just one class. The government has divided every good and service into 45 classes. Often people do fall in the same class. For example, if you're cutting lawns and also pruning trees, both those services are in the same class. But if you're also doing something unrelated, like repairing cars on the side or something wholly different, that would put you in a different class, in a different set of risk, if you will. Each class adds a little bit more. Also, if you file your application when your brand is already in use, it's a different price than if you file your application before the use and then later file a statement of use. It sort of gives you additional applications you need to fill out along the way. So there are some very simple things that change the pricing, but I can tell you that on the front end. But $3,500 is the base price. Actually, taglines and designs are less expensive. So $3,500 is a word mark, which is the name of your company.
Yeah. Well, thanks, Richard. I mean, that's helpful. I mean, I think about off the top of my head, I can't remember exactly what kind of expense we reallocated in my client's case, out of their current agreement. But I think it was easily, there were so many things to change. It was easily for us to fix was probably at least twice that. Plus, I know how much sleep he lost and how aggravated he was. This is your baby, and it's extremely insulting, and now he used it into an opportunity because he slightly modified his company name and then tacked something else onto it that he's been wanting to offer for years and used that for his name. And I hope he's going and trademarking that and learned his lesson. But I do have several clients that have trademarked, and I think it's just a valuable thing that everybody in this industry really needs to do and to find somebody. So if someone would want to reach out to you and get you to do a search for them or go through this trademark exercise, how could they reach you?
Thanks, Chad. Yes, there's several ways you can reach me. If you want to do the old-fashioned way and call us on the phone, our phone number is area code 678-965-3268. If you want to reach out to me via email directly, you can email me at richard@initiatingprotection.com. Also, follow me on LinkedIn. I have lots of videos, at least 2 a week, where I talk about substantive issues. I also talk about me as a personal side of my life. Right now, I'm sharing stories about me as a child. Last year, I had stories about my grandfather. So just things to get to know me, break the mood a little bit. But lots of useful information, things that hopefully any business owner can use.
Well, yeah, that's actually how you and I got acquainted, because I saw you on LinkedIn and I enjoyed your videos, and then this issue happened with my client, like I think a month later, and I instantly remembered you, and I know we've stayed in touch, and that's why I appreciate you coming on and doing that.
Chad, thanks for having me, Dave. Had a lot of fun sharing, and always happy to get on and talk about issues. The one thing I'd really like your clients to take away, though, is don't use descriptive brands. Have something in your name that's somewhat unique. And really quickly, your last name is not unique under that standard. The name of your town or your state or the mountain range you're close to or whatever is not unique. Geographic indicators are not unique. Find something that has nothing to do with your business at all. Maybe your first pet's name, maybe the road you grew up on, just something unique that maybe has a meaning to you, but not to the industry.
Good tips. Good tips. Well, thanks everybody for tuning in. I really appreciate you watching this or listening wherever you may be at. And I really hope that you're hearing my warning. Protect your assets or protect your asses, however you want to interpret this. And so if you enjoyed this episode, you enjoyed this discussion, hey, would you do me a favor and just forward it to some of your industry colleagues? I'm sure that they could use some protection as well. If you love discussions like this, about sales, marketing, and even law as it interjects with that, I would encourage you to subscribe. You can subscribe on landscapeleadership.com to our blog. Follow me on YouTube, look for Chad Diller, or on LinkedIn. There's all kinds of content out there. Thanks so much. Have a really great day.